Ready, start. Learned counsel for the appellant emphasized upon the proviso to subsection within bracket 23 of section 65 of the Act to submit that the handling of export cargo is excluded from the double inverted comma cargo handling service double inverted comma close and as such is not covered under the taxable service as defined under subsection within bracket 105 of section 65 of the Act. At the outset, it would be pertinent to point out that section 65 of the Act is not the charging section but a provision defining various terms in connection with the service tax. Subsection within bracket 23 of section 65 of the Act simply defines double inverted comma cargo handling service double inverted comma close. It inter alia provides that services of loading, unloading, packing, and unpacking of cargo, including certain other services, would amount to double inverted comma cargo handling services double inverted comma close, but would not include handling of export cargo. In other words, handling of export cargo stands excluded from the definition of double inverted comma cargo handling service double inverted comma close. The aforesaid provision does not speak about charging of service tax upon cargo handling service. In order to examine whether the services rendered by the appellant at the airport in handling the export cargo are exempted from service tax, it would be prudent to first refer to section 66 of the Act, which is the charging section. The aforesaid provision provides for levy of service tax on double inverted comma taxable services double inverted comma close as referred to in subclause within bracket ZZM of subsection within bracket 105 of section 65 of the Act. Section 65 is a section which provides for the definitions of certain terms including double inverted comma cargo handling service double inverted comma close and double inverted comma taxable service double inverted comma close. Cargo handling service is defined in subsection within bracket 23, whereas taxable service has been defined under subsection within bracket 105. The definition of taxable service read with subclause within bracket ZZM means any service provided or to be provided to any person by airports authority or by any other person in any airport or a civil enclave. The conjoint reading of subclause within bracket ZZM bracket close with subsection within bracket 105 makes it clear that taxable services are those services which are provided to any person by the airport's authority in any airport or a civil enclave. The aforesaid definition of the taxable service is very wide and takes into its fold any kind of service that may be provided to any person by airport's authority in any airport. Accordingly, all kinds of services rendered by the airport's authority in any airport are taxable services and are chargeable to service tax under section 66 of the Act. It may be pertinent to note that subclause within bracket ZZM was introduced with effect from 10/9/2004. Accordingly, any kind of services, whether in respect of export cargo provided by the airport's authority to any person after inclusion of subclause within bracket ZZM would be taxable service. The definition of double inverted comma cargo handling service double inverted comma close includes various kinds of services rendered at the airport, but it specifically excludes double inverted comma handling of export cargo double inverted comma close. Thus, double inverted comma handling of export cargo double inverted comma close stands excluded from the double inverted comma cargo handling service double inverted comma close but that by itself would not be sufficient to exclude it from definition of taxable service under subsection within bracket 105 bracket close of section 65 of the Act.